Can I put this down? Sorry. Sorry, I've closed down the presentation by mistake. Sorry about that. I hope that doesn't upset anybody. Sorry. It's an honour to be here today to deliver these remarks. It is very nice of Nikos, after all of our tussles over the years, to invite me back. The European Commission is very serious about moving forward on the reform of investment dispute settlement in an open and constructive manner. We speak to all stakeholders, irrespective of their interests and their perspectives on possible reforms. And I'm very glad that I'm here today to be able to, first of all, set out the EU's views, and then secondly, as Nikos and Arif has said, to engage in a discussion with you. And I think the discussion already this morning has flagged a number of issues. I'd like to address three questions rather. First, why reform the investment dispute settlement system? Second, what should a reformed system look like? And third, how should that reform move forward? In short, as per the title of my speech, the path towards a multilateral investment court. But I'd like to preface my remarks with a few words on the European Union's emergence as an actor in the international investment sphere, as I think without that emergence, we wouldn't be here today because there would be no need for an EFILA to exist. And in saying that, I would distinguish very clearly, and I insist on this, the internal from the external. So in its relations with the wider world, the EU has historically been the champion of the liberal multilateral order. The EU itself is a child of the consensus which emerged from the end of the Second World War. With the wider world, it is the EU that has championed the rule of law, arguing for the protection of individuals, upheld international rules, fought for multilateralism, and for the pacific settlement of disputes. It has been involved in or has supported many of the international judicial mechanisms which have emerged over the last 70 years. It has steadfastly defended the WTO. To take a current example, it is the EU which is fighting tooth and nail to preserve the independence of the judicial functions of the WTO from attack. And this is not starry-eyed idealism. This is because we know, and unfortunately in part from experience, that a rules-based international system with a pacific means to settle disputes is key to preserving and providing prosperity for our citizens. And we know that prosperity depends on investment, both inwards and outwards. And we know that the twin biggest challenges of our lifetime require massive private investment. The transition to an economic model which does not ultimately destroy our climate requires massive private investment, and transitioning developing countries out of poverty also requires massive private investment. And we know also that the rules and pacific means to the settlement of disputes encourage investment. That is indeed the very history of the European Union. What is EU law if it is not a means for economic operators to develop their business, secure in the knowledge that they have enforceable rights that protect their business from untoward government actions? That has underpinned the economic growth of all the EU member states over the last decades. So the EU, in taking action to reform investment rules and dispute settlement, does so with a view to upholding international rules and ensuring effective dispute settlement. And that takes me to the internal situation. The EU already has a system of binding rules between its member states, which can be directly enforced by economic operators before the domestic courts of the member states, and ultimately before a transnational, indeed originally an international court in Luxembourg. And we're very lucky to have Sir Francis with us, who is, of course, a distinguished member of that court. It is useful, I think, to point out that this is, in fact, very much like the United States, with the Federal Commerce Clause, which can be enforced in the individual states, the federal courts, and at the apex, the US Supreme Court. Now, I know that the Acmea case has caused much consternation. I noticed everybody was studiously avoiding trying to mention it this morning. But permit yourselves to transplant it to the United States, and I think this is useful for understanding it from an EU lawyer's perspective. Imagine that the states of Texas and Maryland concluded an agreement, and that agreement covered matters regulated by the Federal Commerce Clause, and it used a system of dispute settlement which effectively excluded the jurisdiction of the federal courts. How do you think the US federal courts would view such an agreement? I have little doubt about the answer to that question. And this, I think, and this is important to underline, this is what Acmea looks like, or the Acmea situation looks like to an EU lawyer. It's difficult to be surprised by the result when the Court of Justice said as early as in 1963 in Van Genden Loos that the EU constitutes a new legal order of international law for the benefit of which the states have limited their sovereign rights within limited fields, and the subjects of which comprise not only the member states, but also their nationals. But this is, of course, very different externally. There is no such pooling of sovereignty internationally, not between the EU and Canada, and not between the EU and China. But why then should the EU be suggesting a reform of the existing system of investment dispute settlement? As I mentioned previously, the EU as a child of international law has an obvious interest in upholding international law when it comes under attack. That is key both to our prosperity and our ability to effectively confront the massive challenges which we have before us. However, believing that it is important to maintain this system does not mean that it does not need to change. We cannot be blind to its deficiencies. The key question with the current system is whether it can ensure sustainable development whilst at the same time protecting the right to regulate. And here the first question to ask ourselves is whether there's a problem with the substantive rules. We can ask ourselves why these rules, which exist in one form or another in other legal systems, both international and domestic, are problematic in the investment treaty system, but not elsewhere. This merits our consideration. We think that nobody can seriously object to protection against discrimination, protection against uncompensated expropriation, or basic principles of good administration as encapsulated in the fair and equitable treatment standard. So we don't think that the problem is in the substantive rules. We could, of course, attribute the problem to the fact that economic operators are given the possibility to bring cases at an international level. Why this class of persons and not others? There, though, I would suggest the choice facing us is binary. We could consider that economic operators should not be granted such rights at all. That would be to reverse those 70 years of international law, imply giving up the heritage of the EU itself, and that the European Convention on Human Rights has provided, of precisely providing such enforceable rights. That would also imply, if the EU unilaterally gives up this possibility, leaving EU investors without protections, whilst their competitors, be they Chinese, American, Japanese, or Canadian, have such protections. In the rough and tumble world, which is fast becoming our new normal, that hardly feels like a wise move. Rather, we think we need to seriously think about addressing those gaps in international law where rules either need developing or where we need to think more carefully about how they are enforced, and indeed even whether we should devolve enforcement possibilities on non-state actors. So if the substantive rules are not problematic as such, and the backward step of removing the possibility of economic operators to enforce international rules should not be contemplated, then where does the problem lie? The problem lies, I would submit, in the dispute settlement mechanisms of the current system. The mechanisms that we have in our domestic and other international systems, which make these rules acceptable to our societies in one context, do not exist in this other context. Since the age of the Enlightenment, our societies have created permanent bodies to adjudicate these types of disputes. Bentham, Voltaire, Hamilton showed us the way in our domestic legal systems. And we transplanted those ideas to the international sphere over the course of the last 100 years. So in the EU's view, we need to bring what was brought into the domestic system, permanency, into the investment system. This is because this addresses two of the core and fundamental concerns with the current system. It addresses the lack of predictability in the current system, and it addresses the absence of a deliberative process. In our view, the lack of predictability raises significant questions about the current system. Defenders of the current system will point to cases where tribunals have upheld a state's right to regulate. The Philip Morris versus Uruguay dispute is perhaps the best such recent example, and of course, substantively, at least from the EU's perspective, is a result to be welcomed. But you need to remember that nobody in this room can say with any reasonable degree of likelihood that the tribunal in the future will follow that precedent. We know there was a dissent in that particular case, and we cannot look into what has been called the black box of decision-making to know how close the dissent was, in fact, to being the majority view. And we cannot know what the black box would produce in a similar case with 3 different arbitrators, or another similar case with another 3 different arbitrators. Research suggests that many variables are at play in that black box of decision-making. And how should a government lawyer advise on potential liability? How can an investor know if a challenge to a measure is worthwhile putting their resources into? And how can ultimately stakeholders and politicians have confidence in the system in the future? Now, the investment system is not unique in facing this dilemma. The world trading system faced arguably a very similar dilemma in the 1980s and 1990s. Ad hoc panels adopted different rulings on substantive rules, which in and of themselves were harmless as substantive rules. Some of these panel reports were adopted by the contracting parties to the GATT, others were not. Stakeholders were rightly concerned as to whether the balance was properly being struck between free trade and the right to regulate. And that concern has been banished. And it was not banished by changing the substantive rules. It was banished through the creation of a predictable system. Concretely, the WTO appellate body was created, and that is why it's so important these days to ensure its continued survival. But it was not the case that the appellate body members were necessarily wiser or better lawyers or more experienced than the previous ad hoc panels. They were simply permanent. And because they were permanent, they were collegiate. And because they were permanent, an expectation was built up that they would follow their earlier decisions. And again, because it was permanent, the panels below them followed the decisions of the appellate body, and stakeholders knew that the decisions of the appellate body would be followed. The second core concern we would submit is the lack of a permanent forum for a deliberative process. That is obviously lacking in the international investment system. Domestic and international courts owe their success to being able to situate the legal questions they are examining in broader societal norms. Their success also lies in the constant process of adjustment adaptation, and interaction with legislative bodies. But that can only be done by reference to stabilized case law, and only makes sense when there is an expectation that this case law provides a basis for future decisions. In short, the deliberative process can only operate successfully on the basis of a permanent mechanism. And this takes us back to another lesson from the WTO. Dispute settlement cannot exist in isolation. It cannot be divorced from the normative content of the rules which are being enforced. It is necessary to establish a constant and structured dialogue with treaty makers. And in thinking about such dialogue, we need to remember, and this I think goes back to some of the discussion we had, or we were starting on this morning, that states are not just defendants. I think this is extremely important to keep in mind. In the sphere of investment law, states are law makers, they're law givers, and they're also interested in how their investors are treated abroad. They are not only in the system as defendants. So the basic reason why we should work on creating a multilateral investment court is so that it can address the defects in the system. These defects, we would submit, are in the design of the dispute settlement mechanism and not in the substantive rules themselves. This does not mean we should stop discussing the substantive rules. Much very good work and thinking is being done on the substantive rules, but our initial focus should be on reform of the dispute settlement mechanisms. So what would a multilateral investment court look like? The EU and its member states have published a paper on the 19th of January of this year, setting out in conceptual terms how a standing mechanism for settling investment disputes could be established. At the core of such a mechanism is the idea of establishing permanency. It would entail a permanent body of full-time adjudicators. In the EU's view, it should be two-tier, with a first instance and an appeal. And again, as came up in the discussions this morning, the appeal should not be conducting a de novo review of the facts, but just checking, at least in our notion, just checking that fact finders have reached reasonable conclusions. Again, as the discussion this morning indicated, a key issue will be the procedures for appointment. There, everything should be done to ensure that the appointment of independent and impartial adjudicators. We foresee drawing from the practices, the best practices of recent court constructions to use state-of-the-art techniques for ensuring that we do have independent and impartial adjudicators. So we would foresee an appointment process in which an independent screening mechanism would first of all vet candidates, and only candidates that meet both the high competence requirements and the high standards of independence and impartiality would be shortlisted for appointment. We would want that appointment be approved by majority voting of the constituent members of a multilateral investment court, so as to ensure that no one country can block appointments. And in our view, appointments should be for long, non-renewable terms, since we also know that that is the best way to ensure independence. And just to be 100% clear, I would note that our intention is not to follow the model used by the International Court of Justice. This is actually not something that we refer to in this context in our paper. For us, frankly, that model is outdated. Another key issue is the issue of enforcement. In our view, domestic review of the decisions or awards of a standing multilateral mechanism would not make sense. So it should be, like ICSID, an a-national system of enforcement. This would be provided in the convention establishing the permanent mechanism. And again, in our view, we would also think that it would make sense to seek to apply the New York Convention so as to ensure that we have effective enforcement in third countries who are not party to the convention establishing the multilateral mechanism. Now, the mechanism must be designed in such a way that it can apply to all existing treaties, all 3,000 existing treaties. This can be done, and this is not new, this can be done via an opt-in mechanism. The example in the field of investment is the Mauritius Convention on Transparency for Investor-State Dispute Settlement. But there's arguably, I think, a more interesting and more sophisticated example in the field of double taxation treaties, which is the Base Erosion and Profit Sharing Convention that has been developed in the context of the OECD. In that way, broad application can be ensured. In the view of the EU, it is only, and I put the emphasis on this, it is only such a broad systemic reform which can address the concerns which are identified in UNCITRAL Working Group 3, as those in respect of which reform is desirable. We should recall that the working group has identified 3 groups of concerns. First of all, around the lack of consistency and correctness. Second, around arbitrators and decision makers. And third, around costs and duration. In our view, only a permanent body can respond to the concerns that are identified in the UNCITRAL discussions. And we can, in our view, enumerate at least 10 points that a permanent mechanism, and only a permanent mechanism, can effectively respond to. Let me briefly walk through those. The first is that a mechanism, as I've been talking about, would bring about predictability and consistency. Second, it would bring about correctness. An appeal would correct errors in law and would correct egregious factual errors. Third, a permanent body is the only way that we can address the perceived system of incentives in the current system, where council appoint arbitrators, arbitrators are drawn from the rank of council, and arbitrators rely on good relationships with council for repeat appointments. Fourth, a permanent body can effectively address the ethical concerns which arise. By definition, for example, full-time adjudicators cannot have other activities, so the problem of double hatting will by definition be eliminated. Fifth, a permanent body can provide stronger expertise with more background in public international law and more experience in judging. Sixth, a permanent body, and again only a permanent body, can address the lack of diversity in the current system in both gender terms and in geographical terms. Seventh, a permanent court will reduce costs. Time would not be spent on the choosing of arbitrators. As Philip Sands has pointed out, the current system is incapable of effectively controlling costs. A permanent mechanism will be better able to do this. Predictability also reduces costs. Eighth, a permanent mechanism can reduce the duration of proceedings, even, I would argue, with an appeal mechanism. At a minimum, the time spent choosing arbitrators would be eliminated. And again, a permanent body will be better able to control and expedite the process. Ninth, a permanent body will be better able to manage multiple or parallel claims, particularly if we succeed in having broad coverage and the coverage of multiple treaties. And 10th and finally, a permanent body, through the deliberative process, will be better able to manage the relationship with other areas of law, both international and domestic. And again, we see the WTO appellate body has been very successful at doing that. So what then is the path to get there? From our perspective, it is clear that we need a multilateral forum. This is not about one entity's views. The EU has strong views, but it's not only about our views. It is very clear to us, when we listen to the discussion in UNCITRAL, that countries throughout the world have concerns with ISDS. They come with different experiences, they come with different concerns, their pathways are different, but it is striking that not a single country defends the existing system as such. The papers which the EU has submitted to UNCITRAL are put forward in good faith as a basis for discussion. We expect others to contribute with ideas, suggestions, improvements to our thoughts. For us, it is extremely important to take account of the experiences and concerns which have been accumulated to this point of time. UNCITRAL provides both a multilateral forum and a forum for discussion. We have more than 90 countries who are present, as James was saying, at the last meeting and participating in it. There were more than 400 delegates. This shows the importance of the discussion and the inclusiveness and openness of the process. The EU is keen to ensure that inclusiveness. With the Swiss government, we are putting money into the UNCITRAL Travel Fund, which helps to ensure that developing and least developed countries' officials can attend and can provide input. Given these are significant policy matters, this has to be a government-led process. Governments need to set the agenda and they need to make the concrete policy decisions. And this is something that's been consciously and explicitly built into the mandate of Working Group 3. And I would finish by saying that this is a significant moment for the investment regime. It's probably the most significant moment in its history, or one of the most significant moments in its history up until now. It is the first real multilateral discussion of the ISDS regime. It is the first discussion that is taking place after close to 30 years of experience of an active regime since the first cases were started. We all need, and I very much include the practitioners when I say we all need to use it to make sure that the investment regime is supportive of sustainable development, that it can play a part in helping the international community face up to the key challenges facing us. This is a chance which cannot be missed. And we hope that others, all stakeholders, will engage with the EU in thinking carefully and constructively about how to improve the system. Thank you very much.